In South Africa, employment equity compliance is more than a legal obligation. It's a commitment to transformation and equal opportunity. With the recent amendments to the Employment Equity Act, compliance has become more structured and more critical than ever.
EECMS, or Employment Equity Compliance Management Services, are specialists in the employment equity compliancy field. Backed by several years of proven expertise and a team of senior employment equity specialists, EECMS delivers the expert guidance and support you need to achieve effortless EE compliance with confidence.
From setting numerical targets and drafting your EE plan to generating legally compliant reports and tracking progress throughout the years, EECMS handles it all seamlessly.
EECMS doesn't tell you what to do or how to do it, we do it for you.
So, who must comply with the Employment Equity Act? In South Africa, the EE Act, as amended, applies to all designated employers, including municipalities, organs of state. As defined, employers bound by collective agreement and employers that employ 50 or more employees.
Designated employers are, amongst others, legally required to consult with a representative trade union, where applicable, or a well-established employment equity committee.
Assign responsibility to one or more senior managers to oversee the EE compliancy process.
Consult on, develop and implement an economically active population analysis. This EAP analysis needs to align with sectoral numerical targets determined by the Minister and needs to inform your EE plan of transformation.
Consult on, develop and implement an employment equity plan.
And submit annual employment equity reports to the Department of Employment and Labour.
Non-compliance could result in fines and penalties starting at the greater of 1.5 million rand or 2% of turnover, or up to 2.7 million rand or 10% of turnover.
Non-designated employers can request and obtain a Section 16B compliance certificate based on the following requirements.
Employ less than 50 employees. Is not a municipality, organs of state as defined. Are not bound by collective agreement. Are not paying below minimum wages. And have not been found guilty of discrimination in the preceding 12 months.
Through EECMS and our specialists, each of these legal requirements are simplified, tracked, consulted on and managed through a state-of-the-art online portal and online meetings, making compliance structured, accurate, timely and stress-free.
Stay compliant, stay ahead. Let EECMS become your EE compliancy division today.
For more information, please visit www.eecms.co.za.
Good morning, everyone. My name is Pieter from EECMS. As you may know by now, a company dealing in employment equity, specializing in total and full EE compliance. Employment equity is our only forte. It's the only thing that we specialize in at EECMS. Colleagues, the purpose of this session this morning is DG reviews. Okay, what does that mean? It is certain inspections that is facilitated by the Department of Employment and Labour. There are two kinds of investigations, the one being a procedural investigation, the other being a substantive investigation. The purpose of this session, colleagues, it is to give you more information on the theory behind these investigations facilitated by the DEL inspectors. And then we would love to show you a practical example or two so that you as a designated employer would know what to expect should there be an investigation by the Department of Employment and Labour. Information, outcomes, timeframes, and practical examples. Please note that the presentation is provided by EECMS for informational purposes. It is not intended to offer a general overview of the EE Act in total. The content does not constitute legal advice or definitive interpretation of the EE Act. We will not be held liable for any actions taken or decisions made based on the interpretation of the information presented. For specific guidance, whether it's legal or for the clarification regarding the EE Act, please contact us for a further consultation. Colleagues, I'm going to hand over to one of our senior EE specialists, Sharon Kruger. Sharon.
Good morning, everyone, and welcome to the DG Review webinar. As you all know, I am an EE senior consultant, and I have been working for EECMS a number of years. So what is a Director General Review? So a Director General Review is actually often called the DG Review, which is a formal compliance audit that is conducted by the Department of Employment and Labour. Now, the purpose of this review is to determine whether the designated employer is complying with the Employment Equity Act, not only from the administrative perspective, but also in terms of transformation progress within your workplace. Now, during the review, the department will use the EEA 7 assessment form as an official scoring and assessment tool. And this will assess there. This means that you will be assessed against your compliance indicators, such as your consultation, your reporting, your workforce presentation. And the reason for this is that the department now wants to evaluate whether meaningful transformation is actually taking place within your organization. So let's have a look and see why DG reviews matter. Now, as we all know, DG reviews are actually becoming increasingly important because of the amended Employment Equity Act. Previously, employers believed that, if I submitted my EA2 and my EA4 reports annually, that is it, I am compliant. But the Department of Employment and Labour now expects you to demonstrate active implementation and measurable progress. And this is in relation with regards to the sectoral numerical targets that were promulgated and gazetted on the 15th of April 2025. Also, the DG reviews, that will also be impacted if you are dealing with the state as per Section 53 of the Amendment Act. So these certificates are required by employers who does business with the state or actually tender for any government contracts. Now we're going to have a look at some common DG review triggers. There are common triggers with regards to the DG review. So let's have a look at some of those triggers. Let's say, for instance, you are triggered by employees or trade unions that's actually lodging a complaint. Employers who have applied for a Section 53 compliance certificate. Remember, Section 53 is related to state contracts or when you are dealing with the government, any tenders that you want to apply for and be awarded for. And employers that receive written notices from the Compliance Department of Employment and Labour. So the key message here is that DG reviews are becoming proactive rather than reactive. Now, let's have a look at procedural versus substantive DG reviews. As you can see, it is tabled here on the left-hand side, procedural review, and on the right, substantive review. But let's have a look at this and see what is the difference between the two. Now, a procedural review focuses mainly on your administrative compliance. What does this mean? It means that do you have an employment equity plan in place? Do you have your established employment equity committee? Have you conducted consultations? Is your EA3 summary displayed in the office area? Did you submit your EA2 and your EA4 reports on time, which is due by the 15th of January every year? Now, if we look at the substantive review, now this goes a little bit deeper. The department then evaluates an employer in making to see if the employer has made real transformation progress. So here the focus is shifted. They're going to have a look at your workforce presentation. Is it in line with your numerical targets? Are you achieving those? Your recruitments and your promotion practices, disabilities and your income differentials. So what does this mean in summary? It means that the procedural compliance asks for, did you follow the process? Substantive compliance says, did the procedure meaningful transformation outcomes? So it's not enough that you just need to submit your reports any longer. The Department of Employment and Labour actually wants to see if you have proof of your transformation progress. Procedural inspections that require, firstly, you'll see that it requires consultation and communication. So if we have a look at section 16, and this deals with the representative trade unions.
Thank you. I would like to elaborate. When we are referring to consultation and communication, as Sharon mentioned, Section 16 of the Employment Equity Act, you must have been consulting with your EE committee and or representative trade union, if applicable. Colleagues, what we have noted in the past couple of weeks that the trade unions are becoming extremely active within the employment equity ambience. The trade union, what we have, well, we visited one of our clients on site quite recently, and the trade union was involved. The trade union actually requested this session, and the trade union requested certain information from the shop stewards and or the employment equity committee that also had to be represented in that session. Trade union asking typical things with regards to, and not to the client, not to the CEO, not to the consultant, but directly to the EE committee and or the trade union representatives, asking them, we want to see whether there's substance and or whether you only have your legal form. In other words, we can see you do have an analysis, you do have an employment equity plan, you do have meeting minutes. Yes, you do have a committee, and we do have a representative trade union and or trade union representatives, asking those representatives directly, what are your roles and responsibilities within the constituency of this forum, quorum, and or committee? Did you receive training on employment equity? Are you actually aware of what is stipulated in the legislation with regards to your involvement as an EE committee member and or a representative trade union member? Are you actively involved in the consultation of the EA12, which is your EAP analysis, your economically active population analysis, determining barriers, determining affirmative action measures to overcome those barriers? Were you involved? What was the participation? EA13, your employment equity plan, referring to your numerical targets for year 1, 2, 3, and 4, after which you need to achieve the targets or the goal as at the end of your 5-year plan, 31 August 2030. The questions are asked, colleagues. Gone are the days where you say, whether it's to a union and or to an inspector, there's all my documents, there's my plan, there's my analysis, there's my meeting minutes. On-site visits can be arranged by the Department of Employment and Labour. They can visit you on site, they can communicate via email, whatsoever communication mechanisms, asking these kind of questions. With regards to the EA2, colleagues, before you submit your EA2 report to the Department of Employment and Labour by no later 15th of January the following year, the question could be asked, were you involved in the preparation and of the draft of the EA2? We can see you have the document, we can see you submitted, but were you actively involved, yes or no? So the questions being asked, how often do you meet? What is the discussion points? Colleagues, in other words, in a nutshell, it is extremely important, as Sharon has mentioned, that gone are the days where companies and designated employers say, my paperwork is in order. Okay, we can see your paperwork is in order, but can we have an interview with any of your committee and or trade union representative members asking these questions with regards to consultation and communication pertaining to Section 16 of the EE Act as amended? Okay, I just wanted to come in here, so thank you, Sharon, over to you.
Thank you, Pieter. So if we have a look at reporting and compliance, it is important that your EA2 and your EA4 submissions has to be done annually, and that you receive confirmation of that and that those documents are retained. And also from a governance perspective as well. So the key point here is that employers must keep proper records. It is very, very important, because if there is no documentary evidence, then the department is just going to assume that the activity did not happen. So let's have a look at the substantive inspections, what is required here. So what is required? If we have a look for substantives, the plan, you have to have your 5-year employment equity plan. That is very, very important. Also, are your goals aligned to your sectorial targets? And the plan has to be approved or signed by the CEO as well. Now, let's have a look at your workforce analysis, which is your EEA 12. Has that analysis been completed? Have you identified any underrepresented designated groups? And also, have you done a gap analysis where you can show that you have a strategy in place in order to close those gaps? Now, when we look at the disability representation, that also needs to be assessed.
Correct. We have recently had a DG review pertaining to the Amendment Act. One of our clients and the inspector got involved, and we had meetings and follow-up meetings with the inspector. And it was duly noted by the inspector. Of course, we know that white male disabled is deemed designated, but it was confirmed by the Department of Employment and Labour to request whether the e-manager and top management is aware of that, and even the committee, to say that please remember, if you in your employment equity plan to possibly employ disabled white males, it is deemed a designated employee. But on both sides, number one being you are working towards achieving transformation with regards to disabilities and white male disabled. So you are covering the disabled on the one hand, but you are also covering a designated group that includes white male disabled. Okay. It was important for me to come in here to just explain to everyone that in practice, it is provided by the Department of Employment and Labour and confirmed by that inspection that white males disabled deemed designated and can form part of your employment equity plan, whether it's part of your top senior, middle, junior management and or semi-skilled or unskilled disabled, including white male disabled being this designated groups. Thank you, Sharon.
Thank you, Pieter. So this slide, with regards to implementation and supporting of evidence, it actually shows you that you implemented your affirmative action measures that are linked to your barriers, your recruitment and your promotion plans, your annual milestones, and the quarterly monitoring of your progress. So it is very, very critical that if you shortfall with regards to your priorities, it is important that you need to have reasonable grounds and supportive evidence. And that could possibly include scarcity of skills in the labor market, perhaps a lack of suitability of qualified candidates, or economic or operational constraints. It is important that you need to prepare this evidence in advance so that you can justify the decisions and demonstrate in good faith that you are making effort towards transformation.
Sharon, if I can quickly hop in here.
Sure, no problem.
Thank you. Just colleagues, on that being said, justifiable reasons. As you know by now, there are 7 legislated justifiable reasons for not achieving the relevant sectoral and or EAP targets. Of course, like Sharon mentioned, you need to have your evidence in your employment equity file. But what is extremely important, for the first time since 1998, the inception date of the EE Act, and for the first time as amended, you as a designated employer will need to submit 1, 2, and or more of the 7 justifiable reasons for not achieving your relevant targets. Okay, so in other words, this is not just to say, I've got my justifiable reason in the file. I have my evidence, I have my corroborative evidence. Colleagues, when we submit the EA2 report, anything between 1 September this year and 15th of January next year, we will need to consult with you as a client, as a valued client, to say, what is your justifiable reason? And let's elaborate on that. In the EA2, it's a tick and bash. And just we anticipate that since your numerical targets were submitted to the Department of Employment and Labour, let's say for the first year of your plan, and that formed part of your 2025 submission, we believe 2026, the department will determine by means of their online portal whether you did achieve the first year of your plan or not. How would they determine that, colleagues? You have submitted 2025 your numerical targets for year 1 of your plan, which ends 31 August 2026. So when you go and you submit the relevant report or draft the report and you want to submit to the Department of Employment and Labour anything after 1 September this year, you will find, we believe, that there will be a tracking mechanism by the DEL's portal to say where you achieved or not. And wherever you did not achieve, colleagues, it is a tick and bash, but we're not going to leave it at a tick and bash. You need to work with an extremely fine pencil, because whatsoever you select as a justifiable reason could result in an inspector visiting your company and or requesting the justifiable reasons in evidence to determine whether the department will accept your justifiable reasons and evidence to either provide you with a certificate and or withdraw your certificate of compliance. So for now, the submission, tick and bash, yes. What will follow through thereafter, we believe, we don't know, because it's the first time ever that this section is opened for submission purposes. But we believe then the department will request your justifiable reason evidence. So we know you have a justifiable reason, we know what it is, but we're not going to just stand and stop there. Give us more information substantiating your justifiable reason to determine whether you will be compliant or not. Whether the inspector will accept your justifiable reasons or not, withdraw your certificate of compliance or not issue it at all, or issue your certificate, that is yet to be seen, colleagues, since it has never happened in South Africa before. That is yet to be seen. But I promise you, what we have found out of the current DG reviews, evidence, corroborative evidence, gone are the days where you just say, I couldn't find the correct candidate with the relevant skills. You need to prove it. You need to prove it. Thank you, Sharon. Over to you.
Thank you, Pieter. So EECMS inspections to date. So on this slide, we are actually sharing practical insight from EECMS. We have currently been involved in a total of 15 inspections. Out of these, 7 were resolved at procedural stage, meaning that the employers were able to then demonstrate sufficient administrative compliance and the matter did not escalate any further. However, 8 inspections were escalated to substantive reviews, where the department conducted a deeper assessment of transformation progress and the implementation effectiveness. So EECMS has also observed that there has been an increased focus with regards to on-site inspections by the Department of Employment and Labour inspectors. So we would like to encourage you as our valued clients to maintain accurate and organized and readable records to support your compliance verification if in the event the inspector will be doing an on-site inspection on your premises.
Now, just that being said, we have 161 clients at this point in time. We are busy with 15 investigations, so it gives you more or less a picture. And these are the investigations since 1 September last year up to today. So in other words, these are not the investigations of the past 10 years. We're only referring to the Amendment Act and the investigations on the Amendment Act. 161 clients, 15 we are currently busy with, which is almost 10% of our current client base is currently in some or another inspection with regards to employment equity. 8 escalated, 7 resolved. Feedback from the DG, 0. In other words, when we say feedback from the Director General, we accept your new employment equity plan. Colleagues, when a procedural investigation, thank you for all the information, is turned into a DG review, a substantive investigation, that means the department is saying, we are not happy with your willingness to transform. We want you to cancel your current employment equity plan and come up with an entire new employment equity plan. Should remain still a 5-year plan, start at 1 September 2025, end date 31 August 2030. A whole new employment equity plan. You need to reconsult with your committee again, with your management again. You need to look your priorities. You need to look at the assessment report and the DG review, which I will elaborate on in a practical example. Take that as guidance from the department and come up with a whole new plan. Colleagues, it's not to amend the plan that the inspector is not happy with. It is to completely drafting and implementation of a new employment equity plan, being the 5-year start date 1 September 2025. Thereafter, we hope that either you will receive a letter from the Director General saying we are satisfied with your employment equity plan going forward. This is the plan that you will need to monitor. Or the Inspector or Director General could say, we are not satisfied with your new employment equity plan. What happens from there? We do not know as of yet, but we preempt the following. Should the Director General not accept your new employment equity plan, we believe that the inspector could either say, let's consult further, and we will tell you we are not satisfied. Please relook A, B, and C. Or an inspector could possibly then provide the designated employer with a compliance order or a notice of referral to the Labour Court. And that is then the final step. Then you know it's being referred to the Labour Court and you need to await a date to be provided by the department and the Labour Court, well, basically to present all your relevant information and as to why you came up with a plan that is still not compliant. Okay, again, we have not undergone anything like that based on the Amendment Act because of the member. It's something new. Okay, but this is what we believe might happen going forward. Nevertheless, at this point in time, 15 inspections between 1 September and today, 0 feedback from the Director General, whether we accept your plan or we do not accept your plan. Thank you. Sharon, over to you.
Thank you very much, Pieter. Lastly, I just want to say before handing over to Kass is that compliance is not about having your documentation in place. It is actually proving that transformation is actively happening within your organization. Thank you very much. Kass, over to you.
Good morning, everyone. My name is Kasurika Naidu. You all know me pretty well for the last three years. So a senior employment equity consultant with ECMS, quite busy with DG reviews, hence the reason for this really, really important webinar that we have today, just so that you get an insight. What do we have? What do we need? How do we proceed further? So in the latter part of the slides that I will be presenting today, it's basically just a checklist. Do I need to go back to the drawing board? Do we have documentation in place? And what do we have? If not, how do we move forward? And of course, Sharon and myself as your consultants, you can undoubtedly always consult with us and check, do I have this in place or where do I find it? That sort of thing. So yeah, if there's any questions, as always, our sessions are very interactive. So if at any point you have a question, then just let me know. The DG review process flow. So this is just a sort of timeline of how things would sort of escalate once you get in that process. So it starts with the trigger, of course, and then it goes towards your either a procedural review, as Sharon and Pieter did touch on as well. It's either or. So it starts off with a procedural where this is where you'll then collate all of those documentations in terms of consultation, your EA12, your analysis, your employment equity plan, as well as the appointment letter of your EE manager. So quite important. And of course, if we don't hear back from the inspector, amazing. Of course, if they do, you do hear back, then escalates to substantive review. So as mentioned, that review rather is where your targets are being assessed with regards to, are you meeting those numerical targets? If you are not, where can we improve transformation? Of course, then we get your employer response. So those would be your explanations submitted in terms of what you have collated and sent through. Then your DG outcomes, so that's in the event that you actually do hear back from the inspector, and then monitoring and follow up. And this is just ongoing compliance from the business organization side is where you'll actively, once you've been triggered, once you're in these audits, what are you doing as an organization to then continuously try and meet your targets and ensure that the committee is an understanding of what the targets are. Are we meeting on a quarterly basis and making sure that that is all up to date? Okay, so the department, and I think a lot of organizations also like to use the word tick box. So the procedural review checklist. This is sort of the easier sort of audits when you get an inspection, purely just collecting the data that you would have gone through in the year previously. So currently, when you go through a procedural inspection as at this year, 2026, what the inspectors are looking for is the previous 12 months, whether you consulted on collating that plan with your Employment Equity Committee. So did you consult on them with the barriers, affirmative action measures? Did you calculate your sector numerical targets correctly in your EA13? And how are we transforming the top 4 occupational levels? So, of course, your EE plan needs to be signed and current as at 1 September 25, ending 31 August 2030. EA2 and EA4, of course, needs to be submitted. And as you all know, we at ECMS facilitate that for you. And then the EA3 displayed in your workplace, committee meetings, probably recorded, of course, meeting minutes, agenda, registers, that sort of thing as well. Okay.
So in other words, Kass, sorry, I just quickly want to confirm something. So in other words, when a designated employer submits the EA2 document, can we confirm that the employment equity plan, it's a separate legal document that's supposed to be in a hard copy file? However, your employment equity plan in itself is not submitted to the DEL by means of the EA2. It is only your numerical targets for the following year that is being submitted by means of the EA2 DEL online portal. We can 100%. Confirm that. Perfect.
We can confirm that. So your EA13, we do not submit to the Department of Employment and Labour. There is no said place that you would submit this document. So the EA13 will stay in your organization. And of course, you need to keep a hard copy of this. As Pieter would, if you'd also like to elaborate, Pieter, you did have a discussion, I think over 15 years ago, if I'm not mistaken, on should we go and keep these documents online? And they did confirm with you, Pieter, that the hard copies need to be in the organization.
For at least 5 years after expiry thereof. So please, colleagues, even with regards to the previous act or before the amendment, please retain all your employment equity evidence for at least a period of 5 years after expiry thereof. Okay, thank you.
Perfect. And as Pieter mentioned, how the department tracks to monitor and make sure that you are meeting these targets, there is a section on the EA2 where you will have your annual numerical targets for that specific year and whether you've met them or not. And of course, justifiable reasons, very, very important if you have not met those targets, those numerical targets and objectives for this year. Okay, so substantive review feedback. So, of course, when you get into a substantive review, this is where the integral part of sort of the work and the groundwork needs to go back. You need to go back to the drawing board. As per the recommendations of the inspector, thoroughly you need to look through those documentation and assessments, see where the shortfalls are with regards to what they're asking. And most of the inspections substantive inspections that it gets escalated to, they really want us to look at the transformation that is happening on the top 4 occupational levels. To be very honest, they are not too strict on your semi-skilled and unskilled with regards to the EAP. That is purely targets that you would have set in your organization for yourselves, but try and meet that sector target as best you can. And what we've also noticed that once that sector target has been met in your substantive inspections, they would also like you to try and meet the EAP target as well. So quite important there. So the substantive reviews are really important to go back to the drawing board, see how you are able to transform the best way you can. And in some scenarios, which we have seen, the inspector does allow for consultation, which is quite something new that we have not experienced before. And I think that's quite a good response from the department and the inspectors, because then you sort of, you can state your case. If there's no movement that can happen, if it needs to remain status quo on the top levels, then you are able to state your case in that regard and see the feedback from the inspector, which is quite a good thing. And of course, if you aren't in that situation in terms of your substantive review, what is your buy-in from top management? Have those consultations, open it up to the boardroom and sit and discuss how we are able to transform the top 4, which is most of what the substantive reviews are gearing towards.
Just to clarify something there as well, the past 2 DG reviews that we were involved in, it was actually noted that semi-skilled and unskilled, I will show you in the practical example, where the department also focused, remember your semi-skilled and unskilled, the target, there's only your EAP target, whether it's national or provincial. So there are no sectoral targets applicable for semi and or unskilled. But in our last 2 reviews, we have noted that the inspector is actually also referring to semi-skilled and unskilled, but not towards the sectoral targets. That's important, not towards the sectoral targets, but directly and immediately to the EAP targets. I will show you that in our practical example. Thank you, Kass. Over to you.
Okay, so your employee response feedback. So employee receives preliminary findings report from the DG. The employee has a right to respond in writing to the findings. So of course, if you are allowed the opportunity and there is in a situation that you are able to respond in such a manner, then of course, as mentioned, these points are quite important. Your response is recorded and could be considered before the final outcome from the inspector. Okay, so in this part of the presentation, we will now go through a practical example of a DG review, so a live example of how we tackle these assessments and the end-to-end process of what to do if you are handed with these audits. Of course, if you are a client of EECMS, we hold your hand through it all, but today Pieter will walk us through it. Thanks, Pieter.
Colleagues, thank you very much. Okay, so now that we have a little bit of the theory behind a procedural investigation that might be turned into a substantive investigation, let's look at a practical example. As mentioned, this is a real life current DG review that is currently taking place. Colleagues, so to put everything in a nutshell, the first thing that I would like to share is the EA7 document. Colleagues, so out of a practical point of view, let's talk about the process. You sit at the office and the next moment, your CEO and your EE manager receive an email. Okay, that is the majority of investigations that we are busy with at the moment. That was triggered by means of an email from the Department of Employment and Labour sending the EA7, which you see in front of you, requesting certain information. Okay, so Kass did elaborate on this document. You receive by mail this document, the following instructions from the inspector from the Department of Employment and Labour. I'm not going to go through all of the wording, of course, colleagues. Contact person usually provided by the inspector. Colleagues, if an inspector arrives at your premises on site without maybe notifying you, are they allowed to do that? Yes, they are. Are you, on the flip side, allowed to request the contact detail of the inspector and the Department of Employment and Labour to see that it is actually a government official, to contact the Department of Employment and Labour and say, I have an inspector by the name of here at my premises. They want to do an investigation. I just want to confirm, is it a government official? Can we provide the relevant information to the inspector being on site? So you have one of 2 options. Either you receive by email or even on site, it is allowed. You confirm, should you like, and then you provide the relevant information to the inspector, being Section A, employer details. Okay, colleagues, same details that's usually on your EA2 as well as your EA4 document. You need to compile the relevant information, complete the information, business type, information about your organization, how many people you employ, etc. And this is what Kass was referring to. By means of the EA7, the inspector would request your assignment of your e-manager. It must be a formal appointment letter. So you would say, yes, we did assign one or more senior e-managers. But if you say yes, in other words, if you say no, colleagues, that is non-conformity. In other words, you might be non-compliant. So in other words, you would say, yes, we do have an e-manager, but what is our source document? An e-manager appointment letter clearly stating the roles and responsibilities of the EE manager being the critical link between the proceedings out of the EE committee meetings reporting back to the CEO. Section C, consultation. Does your organization have a forum or EE committee and or representative trade union as per section 16? Yes, we do. But it doesn't stop there. You would need to provide the proof of the composition of your committee, as well as the meeting minutes and the agendas, as well as separate signed attendance registers. Colleagues, should you facilitate your meetings virtually, are you allowed to take your register and your agenda of meeting minutes and mail it maybe off to the relevant representatives that attended to that meeting, asking them to sign off, mail it back to you, mail it back to the other committee members, mailing back to you? You are more than welcome. It is allowed. You can do everything virtually as long as there is evidence that the committee was involved in the consultation process. Section D would be requested by the inspector, your EAP analysis in the format of the EA12. Did you conduct an analysis of the workforce policy, procedures, etc.? Yes, we did. If so, provide it in the correct format of the EA12. Colleagues, please remember, the EA12, as per the amended Act, as well as the amended regulations that were gazetted the 15th of April 2025, there is the new format of the EA12. Please do not use any other format than the latest gazetted by means of the regulations format. Otherwise, you would be deemed non-compliant and or partially compliant. Section E, your employment equity plan. Does your organization have an EE plan in place as per section 20, 5-year plan? Yes, we do have it in place. If you say yes, please provide it in the format of the EA13. Again, that format changed completely on the 15th of April 2025. You cannot take the old format. You are supposed to have been using the latest and new format. For our current clients attending to the session, you don't need to worry at all. Through the online portal that you are utilizing, everything is above board and it is 100% in the correct format. Section F, signature of the CEO, of course, just to sign off that all of the information is agreed on. Now you see the office, you receive this document, you complete section A, and you compile all your relevant documents as per the EA7, as per Kass's explanation a little bit earlier. The inspector then goes through the relevant documentation and say, you know what, we are either satisfied, it stops there, thank you very much, and you most probably will then receive a letter from the DG to say we are happy with your employment equity plan, but in more cases than not, you would then most probably receive the DG recommendations. You will see all of the relevant information from the inspector as well as the company is grayed out. Dear employer, in terms of section 43, the DG may conduct a review. Please find attached the report with the outcomes. So we scrutinized your analysis. We went through your plan, your appointment letter, your agendas, your meeting minutes, etc. And then the inspector might turn around and say, okay, I'm turning this now into a substantive investigation, a substantive Director General review. And I'm going to explain to you where myself being the inspector is not satisfied and that you will need to work on. Your organization is hereby directed to comply with each of the recommendations. Furthermore, your organization is obliged to submit a report to the DG in terms of the EA2 and the EA4 before 15th of January the following year, signed off by the Chief Inspector. And herewith the General Review recommendations. Background, colleagues, I'm not going to bore you with all of the theory behind this. The purpose of the Act, you know what the purpose is by now. A review of a DG is allowed to request any information with regards to employment equity compliancy, the outcomes, to approve your employment equity plan or to make recommendations. Of course, failure to comply with the recommendations could result in non-compliance and a referral to the Labour Court. Now, what you would find is that we are going to focus only on the analysis and the employment equity plan. So we sit with our clients And then the department inspector says, we are happy with the E-manager appointment letter. If your E-manager appointment letter is not compliant with the latest regulation and the latest stances as per the DEL, then you would have noted here where it might have been stipulated you are not complying with Section 24 of the Act due to the following reasons. That you are not compliant with your employment equity plan. And this is the example here. The employer has submitted an E-plan with a duration of 5 years. The plan was analyzed by the department and the following were observed. The numerical goals set by the employer do not comply with applicable sectoral targets in terms of Section 15A that applies to the employer. Section 15A refers, colleagues, of course, to your sectoral numerical targets. Where do you obtain that? Out of the regulations gazetted the 15th of April 2025. Okay, so again, sectoral numerical targets, it's a new thing, and 2025 was the first time that you had to submit a new plan based on the sectoral numerical targets once reached, working towards the EAP targets. Furthermore, the numerical goals stated do not address underrepresentation of other designated groups as there is inequitable representation in other occupational levels. So out of the hundreds and hundreds of possible queries or non-conformancies that the inspector could pick up out of your employment equity plan, because remember, your plan is supposed to have been drafted to comply with the codes of good practices of how to draft, implement, and monitor your employment equity plan, and that was gazetted 2017. So we had to go back and say, let's go back to 2017 and let's look at all the rules of an employment equity plan. Whereas with this company, the department said, we are 100% happy with the wording. Your employment equity plan is 100% in compliance with regards to the paragraphs, the barriers, or the analysis, etc., except we are not happy with the willingness to show increased transformation compared to the EAP and or the sectoral targets. Then we take note, the employer is not compliant with the provisions of 15A, 220, 2C, etc. A recommendation, the employer must develop and implement an EE plan in terms of the EE Act, and the duration of the plan may not be shorter than 1 year or longer than 5 years. The numerical goals and annual targets to achieve the equitable representation of suitably qualified people from designated groups. So we are including African, Indian, colored males and females. We are also including white females being designated groups, as well as white male disabled being designated groups. So that is the problem that the inspector had with this scenario. In developing the numerical goals and the annual targets, the national demographics of the EAP and sector targets must be considered. Numerical goals set by the employer, numerical goals, colleagues, we are referring to the end of your 5-year being 31 August 2013, must comply with the educational sector or the agri sector or the manufacturing sector, depending on the sector that you operate in. Each sector, of course, have different targets. In terms of top senior professional being middle management and skilled being junior management. The numerical goals state that semi and unskilled level must be informed by the EAP only. Further recommendations, rising opportunities must be distributed amongst the designated groups to address the underrepresentation. The company's recruitment and skills development initiatives should be linked to your employment equity plan. The plan must also outline timeframes for the achievement of non-numerical goals. So, colleagues, remember, as part of the Codes of Good Practice 2017, your plan must comply and adhere to the SMART principle. SMART being specific, measurable, attainable, reasonable, and time-bound. The plan must outline the stakeholders for monitoring, the EE committee and various stakeholders, top management, EE manager, EE committee, representative trade union, if applicable, etc. It must also include senior managers responsible to monitor the plan. Now, colleagues, let's talk about timeframes. Once you receive the EA7, you compile the documents. You have 5 calendar days to compile the documents and send it off to the inspector. Colleagues, in other words, 5 calendar days. If you have not done any meeting minutes, or whatsoever the case may be, you have 5 calendar days, not work days, 5 calendar days to provide the inspector with all the relevant information. You cannot go and quickly draft meeting minutes for the past year and backdate it, etc. That is, of course, not allowed. You have 5 days to provide the relevant information to the inspector. The inspector then scrutinizes through the relevant documents. Should it be turned into a substantive investigation, like you are seeing in front of you with regards to a substantive DG review, the department usually gives you 30 calendar days. In that 30 calendar days, you need to come up with a new analysis as well as a new employment equity plan. You need to consult with management. You need to consult with your committee. You need to get it finalized and need to also have your meeting minutes, agendas, and signed registers. On top of everything that you had in the past, you, in a DG review, need to indicate that you did consult the new employment equity plan. You usually have 30 calendar days. If this company was found non-compliant with other relevant sections of the Act, it would have been noted here, which in this case is not applicable. Colleagues, guys, and now you have your 30 days, calendar days. You have to sit with your management, your committee, and so forth, and you need to then come up with a whole new employment equity plan, which I just want to show the following step, being the assessment report. Usually, when you receive your DG recommendations, you have 30 days, do your new employment equity plan, etc., etc. But with that, usually comes an assessment report. The assessment report is more detailed with regards to where the inspector, by means of the Director General, can say, herewith are the following occupational levels: top, senior, middle, junior management, semi-skilled and unskilled, as well as the disabled or people living with disabilities, where the inspector is not satisfied with, and basically just guiding you in terms of a new employment equity plan. This report, the DG, conducted in terms of Section 43, XYZ is a private company. The accounting officer is. The company is recorded as the duty, or the person, following person is recorded as the assigned E manager. Colleagues, so it's just a couple of things that the department come back to you and say, okay, we take note of the following. You had a total of 863 permanent employees, 7 people with disabilities. Okay, so it's just the department and the inspector taking note of what was submitted. Foreign nationals, out of previous experience and current experience, colleagues, we have noted when it comes to foreign nationals, the inspector usually have questions on the foreign nationals, especially if it's an unskilled and semi-skilled foreign national. The department inspector could ask you, but do you really want to tell me that you could not find a South African citizen to occupy an unskilled and or semi-skilled level? And maybe even junior management, a supervisor, a foreman, a boilermaker. Do you really want to tell me as the inspector that you cannot find a South African individual to occupy that, when you are referring to middle and maybe senior and top management? You can turn around and say, but we employ X number of foreign nationals in top and senior middle management, whatsoever your case may be. But what is the reason for that? You could say it's due to the scarcity of skills. Then the department would come back and say, okay, give us a plan, a skills transfer plan on how you, being the designated employer, will ensure that the foreign national transfer the skills to a South African individual. So that should the foreign national, either through natural attrition and or end of contract, leave the employer of the designated employer, to be able to say we're transferring those roles to a South African individual and not a foreign national. Transfer of skills policy with regards to foreign nationals. Do you have such a policy in place or not? Colleagues, if you do not have such a policy in place, go onto the TAP EE online portal, go and click on documents. There are almost 30 additional policies we have uploaded there for you. There is a foreign national transfer of skills policy. Please utilize it, go through it, amend it to fit your business and your business operations, and just ensure that you are not on the back foot should a question be raised by the Department of Employment and Labour. Issues to be determined, whether you do have an assigned EE manager, have you consulted, do you have an analysis, a plan, etc. Okay, we went through that quite thoroughly. Then the inspector would indicate the survey of evidence received from the designated employer. Thank you, we received your appointment letter as EE manager, EA12, EA13, EA2, etc. And then this is the crucial part, where the department then analyze your numerical goals. So colleagues, the department, do they look at year 1, year 2, year 3, and year 4 of your employment equity plan? I personally do not think necessarily, because remember, year 1, 2, 3, and 4, you as the designated employer can come up with your. However, by year 5, which is deemed your numerical goal, as at 31 August 2030, is where the inspector and the Director General wants to see, are you working towards your 5-year goal and the sectoral numerical targets, taking into consideration the EAP, of course. Then the department would say there's an observation. Okay, so let's first see how this works. At the bottom, you would have your current employees as at 31st of August 2025. It is distributed, of course, between your African, colored, Indian, white males. So you look at the department looks at the current workforce as at the start of your employment equity plan between the various races and genders. This company having 6 people in total at the start of the plan. And then the inspector would look at your, not necessarily, but you would show you your numerical targets for year 1, 2, 3, 4, and 5. Because you provided the inspector with your employment equity plan, so now they have all your numbers, and then they would focus on the numerical goals as at 31 August 2030 and say, hang on, we are considering the targets for designated males and designated females. And let's observe, designated males are not represented at this level, sitting at 0% compared to the sector targets. So in other words, if we look at designated males, there are 0 African males, 0 colored males, 0 Indian males, and 3 white males being non-designated. However, the target is 27.6%. Designated females are represented above their sectoral target, sitting at 50%. So in other words, if we look at the designated females, there is a 1 African female, a colored female, a white female, equals 3 out of a total of 6, equates to 50% of the workforce profile in top management equals designated females. However, the target is 46.1%. So ideally, the department would like in this regard to say, let's focus on where your underrepresented races and genders are. But before we do that, we're going to look at the 5-year plan or the goal and then come up with the following observations. White males will remain overrepresented. How does the inspector know this, colleagues? Because as at end of August 25, you had 3 white males. Year 1, year 2, year 3, and even year 4 and 5 of your plan is to remain and retain the 3 white males. So the statement here is white males will remain overrepresented. Should opportunities arise, they must be utilized to address the underrepresentation. So if you look at the relevant targets, you would find that most probably in this example, your highest underrepresented race and gender in top management would be an African male. If we look at these steep targets, whether you are using provincial or national, you take into consideration the sectoral numerical target. Should an opportunity arise, you will need to focus on priority number 1 being an African male. If not, what is your justifiable reason for not employing and or promoting into your priority number 1, or maybe even priority 2, priority 3, etc. Okay, colleagues, so in other words, it's an ongoing process. Hence the reason we are in very big consultations with regards to service provider to say, can we have a module which we hopefully will be released before end of May, where we want to show you as one of our valued clients, when you promote or terminate or recruit, can you have a module to say, I've recruited 2 people and I want to see after I've recruited them, updated the portal, where are my new priorities? Not as at 1 September last year. I want to see my priorities as at today. Because out of a DG review, should an opportunities arise, you must utilize the highest underrepresented races and genders. Colleagues, we are working on that module. We hope and pray it will be uploaded, tried and tested and published before end of May as promised with our previous emails, so that you will be able to say, I want to see my company as at today, not 1 September 2025, but today. Okay, moving on to senior management, also more or less the same, colleagues. You will see again the department the inspector will show you your workforce as at end of August 2025. In senior management, 32 employees, and the numerical goal as at the end of the 5 years, 40 employees. Okay, so there's a +8 employees, whether there's maybe terminations and or promotions or new recruits, whatsoever the case may be. We anticipate a growth from 32 employees in senior management to 40 employees. But let's look at the observation. Designated males are underrepresented, sitting at 9% as compared to their sector target of 30.5%. Now, how do we get to that? Designated males, a total of 3 divided by a total of 32 employees equals the 9%. But the sectoral target is 30.5% as at the end of August 2030 for senior management. Designated females are sitting at 48% compared to the target of 46%. Okay, so it's almost on par there. It's a statement by the inspector. White females will remain overrepresented for the duration of the plan, sitting at 25% above the EAP target of 4.1%. Okay, so in other words, white female target, and it's overrepresented. Should opportunities arise, must utilize to address underrepresentation. Now, colleagues, what we have seen in practice, what the inspector usually requests in this scenario is to say, okay, we can see that your designated males are underrepresented. We need to go and see the highest underrepresented, whether it's an African male, a colored male, or Indian male, your current compared to the target. And then usually the inspector would say, please provide me a new plan to maybe show that you started off with 10 white males. You are ending your plan anticipated 10 white males out of the 40, which is 25%, which is still highly overrepresented if you look at the EAP targets, national and or provincial. And then the inspector could request to say, show the willingness to comply with the sectoral numerical target. In other words, is there a possibility you started off with 10 white males that you could indicate that there may be, let's say, 7 white males at the end of the 5 years, and the 3 maybe that might have been leaving or will leave, whether it's through natural attrition, retirement, whatsoever the case may be, to focus on the underrepresented race and genders and build that into your new employment equity plan. Then we say, but inspector, these 10 employees, they've been with the company for the past 10 years. We believe they will be there for the next 5 years. It then becomes a consultation process, as Kassrika has mentioned. We can then possibly say, we are able to say 10 to become 7 if through natural attrition. Remember, you are not allowed to terminate the services of any employee to satisfy the Employment Equity Act. That is a specific instruction by means of the legislation and the regulations. You are not allowed to terminate the services and say, I've done this for my EE compliance here. Okay, but should through natural attrition, if you say 7 white males at the end of the 5 years in senior management, but your plan is maybe to have 7 instead of 10, and you, after 5 years, still have the exact same 10 white males in senior management, colleagues, then that is a justifiable reason. There were no recruitment opportunities. There were no promotion opportunities. But be extremely wary that you then remain with the exact same 40 people. If 10 people out of the 40 people leave the company and you do not employ at all in the next 5 years, you will be compliant because there were no recruitment opportunities. However, if you employ outside of your priority and you do not have a justifiable reason with the evidence, corroborative evidence, to be able to stand in a court of law, then you will be deemed non-compliant. You will forfeit your certificate of compliance. You would most possibly forfeit your management control element on your BEE scorecard, and you could be referred to the Labour Court for steep penalties starting at 1.5 million rand or 2% of turnover, the greatest of. Okay, colleagues, so we're playing around here with ideas. Usually we advise, let's consult with the inspector, let's have a like a chat, let's build a relationship, and let's take it from there and get advice, maybe not advice, but maybe more information from the inspector. We explain our business operations. We explain that due to the following geographical area, whatsoever the case may be. Foreign nationals, there's 2 foreign nationals in top management. Please understand it's from a company overseas that has shares in our company, and they insist on the 2 foreign nationals. Should your explanation and reasoning be valid and makes business sense, then surely it will be accepted by the Department of Employment and Labour Inspector. Professionally qualified. I'm not going to go through everything. I think everyone is getting the gist of where we are going with the percentages and the targets. There's an underrepresentation of designated males. Designated females, 59% above the target. Planned increase of African males and females is acknowledged. If there are any spelling mistakes or whatsoever, colleagues, this is not our document. Indian males, white males, colored females, white females will remain above the EAP. So the department would like to see, when you come up with a new plan, what are you going to do to focus on the already overrepresented, to focus on the underrepresented with regards to new employment equity plan. Skilled technical or junior management. At this occupational level, underrepresentation of designated males, African, Indian, colored, as well as white disabled males, sitting at 37%. Designated females, 56% above. Planned increase of African male and females acknowledged. You need to set the numerical goals to indicate an intention or the willingness to maintain the status quo for colored males, Indian males, colored females, Indian females, white females. These groups will remain overrepresented, colleagues, and that is where the inspector would say, please provide me with a new plan. Of course, you need to do your analysis first to identify where your underrepresented race and genders are, and then come up with a whole new employment equity plan in a substantive DG review for that matter. Semi-skilled, remember, with regards to semi-skilled and unskilled, the focus is only on the EAP targets and not the sectoral numerical targets. Hence the reason you will see there's only EAP targets whether you utilize national or provincial based on the rules of which you are supposed to select. Observation, African males underrepresented, African females overrepresented. You need to set goals to indicate the intentions or the willingness to increase Indian males, white males, disability, Indian females, etc. Colleagues, unskilled, African females underrepresented, African males underrepresented, African females over. Please reset your goals to indicate transformation. African males are over for the duration of the plan. So a lot of times we sit with maybe a prospect or a new client, and the client says, but ECMS, you know what? I cannot understand why I'm in an investigation. We only employ African males and African females. That is what employment equity is about. What is the problem? We only have African males and females. Colleagues, that is not good enough, because there are other races and genders with relevant targets that you then need to focus on. Disabilities, So the inspector would then, by scrutinizing your documents, to see what's your current disabled employee count, what is your planned employee count, and then it will show you here, employee with disabilities is at 1%. Your plan is to, goal at the end of 5 years is to remain at 1%. So in other words, the 7 people remaining the same 7. You remember we had numerous consultations to say, colleagues, please focus on disabled. The department is becoming extremely aggressive, if I may, when it comes to employing the disabled, people living with disabilities, and or even as part of your plan. So we can see the employer appointed 7 disabled. The goal indicates to remain status quo with the same 7, and or at the end of the day 7 disabled. More efforts to be taken to include employees with disabilities. As we all know, there are 18 sectors. All 18 sectors, the target is 3% disabled of your workforce. For every 100 employees that you employ, the department would like to see that you try your best to have 3 out of the 100 being disabled and or employees living with disabilities to achieve that target by the end of the 5 years. Please remember, we have mentioned this on numerous occasions before. Kurt, if you can maybe just input your contact number, your cell number, as well as your email address into the chat box. Colleagues, if you need any further and more information on, you might maybe need learnerships, disabled and or not, on-site and or off-site. Maybe you want to maybe invest to see whether you can absorb some of the disabled employees, which is of course ideal. Talk to Kurt, please. Kurt, you can include your contact number as well as your email address there. If you need any further advice, we will then provide you with the information of a service provider that will be able to assist you in that regard. We are not specialists in the field.
100%. Thank you, Pieter. I'm busy doing it now.
Thank you, Kurt. Okay, analysis of evidence. The employer submitted a letter assigning whosoever as the e-manager. The e-manager is a senior person. So there's a couple of rules, colleagues. If you don't comply with those rules, you would be non-compliant and or partially compliant. There we can see the employer is compliant. Consultation process that Kass mentioned, out of the EA7, the employer submitted the following documents dated those relevant dates. The employer is compliant. EAP analysis, the employer is compliant. But the employment equity plan, we are not 100% satisfied because you are not complying with the willingness to show transformation towards the end of the 5-year plan. Summary of findings: comply, comply, does not comply, and comply. Focus point in this practical example: employment equity plan. Of course, you need to revisit your analysis and then to determine your underrepresented rights and genders, but then come up with a new plan with regards to the willingness to transform. Colleagues, we do have another example, which, however, I'm not going to dig into it. It's 2212. I'm sure there's a number of questions. Sharon, do you agree that I don't necessarily, because the other DG review is more or less the same and or similar than?
I agree with you, Pieter.
Perfect. Okay, I just then want to, before we open for Q&A, I want to hand over to Sharon. I think we have to hand over to you, to Kass.
To Kass.
Kass, over to you, please. Thank you.
Thank you.
Perfect. Thank you so much. Okay, so the DG review monitoring and closure. So in a nutshell and in totality, with regards to these DG reviews, maintain the fact that you, or not maintain, but just make sure that you have your employment equity plan in place. You have your analysis in place, you have records of consultation with your employment equity committee. The constituency of your committee is correct. In fact, of course, if you have a registered trade union, a majority registered trade union, you will then consult with the unions. But just ensure that before, or heaven forbid, you get into the inspections, that all of these documentation is in place. You have submitted your EA2, your EA4, your EA13 is signed by the CEO. Of course, that date needs to be 1 September 2025. Over to you, Sharon.
Thank you, Kass. You can leave it there. That's fine. Thank you very much for that. So this slide summarizes the possible outcomes that may result from your DG review. So if we look at no further action, this actually means that the Department of Employment and Labour is satisfied and with both your procedural and substantial reviews. your written undertaking. This happens when certain shortcomings are identified, but the employer then agrees to implement corrective actions within the specific time frame. Compliance order. This is a formal instruction issued by the Director General requiring that the employer needs to correct specific areas of non-compliance. Labour court referral. This means that the Department of Employment and Labour may pursue legal enforcement proceedings. And then Section 53 implications. Employers who have been found non-compliant may struggle to obtain or even renew their compliance certificate required for state contracts or any government tenders. And then follow-up reviews may be scheduled. The department may revisit the employer within 12 months to verify whether corrective actions were implemented and whether progress has improved. So the aim with regards to employment equity is to make it your everyday business practice. It's not something that you need to rush and fix when there is an inspection. So I would actually encourage everyone in this meeting to actually try and make it part of your everyday business. Thank you very much.
Thank you.
Thank you so much, Sharon. Just so, in conclusion, our key takeaways. Just submitting your reports, not enough. Of course, we need to go back to the drawing board, ensure that we're trying to meet those numerical targets as best way we can. Make sure that there's good record keeping. There is active involvement from top management on a continuous assessment with regards to the organization and the 5-year plan that has been put in place. That last point there, where we say quarterly monitoring reduces compliance risk. So yes, we have our quarterly meetings that we facilitate on a quarterly basis with the committee, with the EE manager, but it shouldn't stop there. It should go back to having those consultations with top management, HR, line managers, understanding what those priorities are with regards to our targets and our numerical targets, objectives for that year. And if we're not, of course, trying to transform, or that is not possible, then what are our justifiable reasons? What is our reasonable ground for not meeting those objectives, and how valid is our evidence? So, just ensuring that validity of your evidence is appropriate and backed up, and of course it is saved in a centralized spot that all line managers, HR, as well as top management have access to as well. So those are my key takeaways.
Thank you, Kass. And I think it's very important out of this session. And if there's one thing that you are taking out of this session, compliance extend beyond reporting, substance over legal form. Colleagues, of course, your legal form must be there, your plan must be there, your analysis must be there, etc., etc. But substance over form is a principle indicating that the true economic reality, and in this case, practical outcome of a situation should take precedence over its literal, legal, and or technical appearance. It means prioritizing what is actually happening over how it is formally presented. We have seen that with on-site meetings quite recently. When it comes to the unions, we can see you have your paperwork. But what is actually happening? The same with the DL inspectors. Remember, the DL inspector is allowed to interview your committee members individually and or as a team. We can see all the paperwork is signed off, but are the people being called in to just say quickly, tick and bash, sign, or what is actually happening? Were there actual consultations? And that is something we have noted by means of the unions as well as the inspectors, placing more and more pressure on companies with regards to, is there actual substance or is it a tick and bash exercise? That is extremely important. If this is the only thing you take out of this session, then you're a full way. Okay. And then just the last slide, I think it's just our contact information, if I'm not mistaken. Colleagues, there is my contact details. At any point in time, you are more than welcome to contact any one of either myself, Sharon, Kass, or Kurt at ECMS. I just want to close off with thanking everyone for your valuable time this morning. When it comes to DG reviews, if any questions, you're more than welcome to contact ECMS. Of course, we will email you the presentation as well as the recording so that you do have that on hand as well. So from ECMS, including Sharon, myself, Kurt, and Kass and Sharon. We thank you very much.
In South Africa, employment equity compliance is more than a legal obligation. It's a commitment to transformation and equal opportunity. With the recent amendments to the Employment Equity Act, compliance has become more structured and more critical than ever.
EECMS, or Employment Equity Compliance Management Services, are specialists in the employment equity compliancy field. Backed by several years of proven expertise and a team of senior employment equity specialists, EECMS delivers the expert guidance and support you need to achieve effortless EE compliance with confidence.
From setting numerical targets and drafting your EE plan to generating legally compliant reports and tracking progress throughout the years, EECMS handles it all seamlessly.
EECMS doesn't tell you what to do or how to do it, we do it for you.
So, who must comply with the Employment Equity Act? In South Africa, the EE Act, as amended, applies to all designated employers, including municipalities, organs of state. As defined, employers bound by collective agreement and employers that employ 50 or more employees.
Designated employers are, amongst others, legally required to consult with a representative trade union, where applicable, or a well-established employment equity committee.
Assign responsibility to one or more senior managers to oversee the EE compliancy process.
Consult on, develop and implement an economically active population analysis. This EAP analysis needs to align with sectoral numerical targets determined by the Minister and needs to inform your EE plan of transformation.
Consult on, develop and implement an employment equity plan.
And submit annual employment equity reports to the Department of Employment and Labour.
Non-compliance could result in fines and penalties starting at the greater of 1.5 million rand or 2% of turnover, or up to 2.7 million rand or 10% of turnover.
Non-designated employers can request and obtain a Section 16B compliance certificate based on the following requirements.
Employ less than 50 employees. Is not a municipality, organs of state as defined. Are not bound by collective agreement. Are not paying below minimum wages. And have not been found guilty of discrimination in the preceding 12 months.
Through EECMS and our specialists, each of these legal requirements are simplified, tracked, consulted on, and managed through a state-of-the-art online portal and online meetings, making compliance structured, accurate, timely, and stress-free.
Stay compliant, stay ahead. Let EECMS become your EE compliancy division today.
For more information, please visit www.eecms.co.za.